Good morning. Are you Dakota Coon? And Mr. Lewis, will your client waive the formal reading of the motion?
He does, yes.
Mr. Coon, in clause number 23, DCCR 0968, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 1st of 2024 for the lesser offense of attempted assault on a family member by impeding breath or circulation, a state jail felony, and that was a 2-year deferred probation. Is that correct? And then count 1 alleges that you violated your probation. It alleges that you committed the new offense of possession of a controlled substance, May 12th of 2025 in Chambers County, Texas. And is that true or not true? Count 2 alleges that you violated your probation by possessing a drug, cocaine, at the time of that arrest on May 12th in Chambers County. Is that true or not true? Count 3 alleges that you failed to never become intoxicated in that you provided a urine sample April 30th of 2025 that tested positive for cocaine. Is that true or not true? Count 3 alleges that you provided a urine sample May 9th of 2025 that tested positive for cocaine. Is that true or not true? Count 5 alleges that you provided a urine sample May 21st of 2025 that tested positive for cocaine. Is that true or not true? Sure, the state abandoned 6, 7, and 8. Did you enter your pleas true to counts 1 through 5 freely and voluntarily? Okay, and did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
No, Justin.
It's admitted. Is there any evidence that Mr. Coon is not competent?
No.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of attempted assault on a family member by impeding breath or circulation. Sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You should read that written admonishment to see what devices qualify as a firearm or ammunition. Also, if you have any questions about how long that lasts, any of those laws, you can talk to Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff. I was going to try to shorten it. That didn't work. That's good. I need to write out what I want to say. I did it once right today. That was it. Too many words. Mr. Lewis, you've got Camden Jackson. There. But James Ford didn't count any of these. She hadn't handed any, I didn't know. Okay, my computer's slow. Good morning. Are you Camden Jackson? And this is 25 DCCR 0114. Mr. Jackson is charged with engaging in organized criminal activity. Mr. Lewis, what is the announcement?
Well, Judge, this is one that we had accepted in the last setting, because he had not used medication to try to shortly after the setting, he wasn't using medication, been on his medication since. And since he's been on the medication, we have any jail write-ups or any issues of what we previously been seeing before all this started.
Okay.
And,
yeah, I remember. I did send an email, made a call.
right.
Okay, so where are we now?
Well, I've talked with the state about the situation. We're in hopes that now since we likely got this issue resolved, with this medication, we can go ahead with ISF condition and continue on. That's what the whole came from. This
Oh, this shows. Sorry, it doesn't show him TRP on here.
Yeah.
Okay, sorry. Okay, so. We haven't gone through the motion, gotten any pleas on the motion, or.
At this point, the court wasn't debating guilt. The focus shifted to mental health, behavior, and public safety. Treatment was offered, but only with zero tolerance going forward.
Ms. Lopez, would you raise your right hand, please, ma'am? Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thanks. So what your position?
Well, yeah, I would like to point out just a couple of things. Originally, this transpired because he was sent to IW to get him for the write-up in the jail. He then received another write-up. It was enough for you to ask me for specifically request that I filed an HRT. I received an email from her that stated that you specifically sent the report for it to be sent to me. And so that was why the NCRP was filed. Since then, we've had quite a few jail incident reports. I actually went and saw Mr. Jackson out of the jail in August 28th and 25, in which I informed him of the NCRP being filed, and I advised him, hey, you really need to behave while you're out here, because at this point you are going back to county your judge. Now I understand that since he's been on medication, he has not had any. My request at this point would be that the secret to Mr. Jackson waiving his medication, then I am still in favor of him going to ISF cognitive. However, I would suggest that he be placed on the mental health initiative caseload, run the caseload afterwards, because the only way Mr. Jackson is going to be able to function and behave in society is with mental health management. He needs to be on the mental health caseload. Additionally, however, I would say that it needs to be established that he be on zero tolerance. He's acting like this in jail. He's acting like this in the community.
Agreed.
And then I would also truthfully suggest that once he completes the mental health caseload, he then come to the high medium risk caseload. Because additionally, if he needs all this help in order to behave, he needs to have supervision long term or longer term. That's not to say that he won't ever end up on a regular felony caseload, but if he's having as much trouble behaving in jail, then they will be able
I don't disagree with any of that. Do you, Mr. Lewis?
No, I don't, Judge. This is just a situation where, once I was appointed, of course, I had him evaluated, competency, and then to the point where when I realized that he hasn't done any medication the third time he's been in custody, that definitely stuck out to me, just the fact that in this short time since he's been on his medication, he's made a difference, and definitely those issues with mental health issues that need to be addressed, to make sure that probation does the help he needs, the proper vehicles for him to be successful.
What medication did they start, Mr. Jackson? You don't know what it's called? You take it every day? And when did that start?
About a week or two after.
I,
Right.
okay. These are all the last one that I show is from December 23rd. Thank you. So then what I need to figure out then if there's obviously a motion pending. So either we go through the motion and I continue him with these. I think I'd rather do that than just dismissing the motion with new conditions. I'd rather go ahead and go through the motion, get pleas of true on that. I'll agree to what everybody's saying, but I think I want to do it the more formal way.
Okay.
So let's go ahead and go through that motion. Mr. Anders, raise your right hand, please, sir, the best you can. Not Mr. Anders, I'm sorry,
Jackson.
Mr. Jackson. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Okay, put your hand down. So, let me get it pulled up here. And so the ISF was just, we didn't go through any of this. We've ever. That was just part of that was an agreement with regard to admin hearing. All right, so,
One of the conditions is his probation program that we
right.
have no further issues.
So we never even got,
Before we paperwork, ISL.
okay. So you haven't seen the light of day yet? You ready to? Okay, well, we're going to give you the tools to do that. But it's going to be up to you to take advantage of all of it, okay? So you can see by what happened last week, if you ask and say, hey, I need something, then a lot of times people can help you. Y'all let me know that. I was able to contact the jail. Things happen. So the important thing about all of this when you're on probation, whether you're in jail, whether you're at ISF, or when you get out, hopefully, if you're having things that aren't going right in whatever part of your life, your probation officer is going to be there to help you. They're not trying to revoke you. They're not trying to get you in trouble. They don't know if you need something unless you go to them, right? Okay. So I'm going to go through this motion and ask you for pleas of true or not true to the allegations in the motion. So in clause number 25, DCCR 0114, have a motion to revoke your unadjudicated probation. Shows that you were placed on probation August 5th of 2025 for the offense of engaging in organized criminal activity, and that was a 7-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to conduct yourself in a courteous and professional manner by disrespecting a female correctional officer by showing her a video that was lewd and sexual in nature. Is that true or not true? Count 2 alleges, count 2 is really the same. Okay. All right. So did you enter your plea of true to count 1 freely and voluntarily? And did you plead true because that's actually true? And so, well, let me go through this and then we'll talk about it more. So I'm going to find count 1 true, find that you entered that plea freely and voluntarily, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to continue you on probation. You are still ordered as a condition of the probation, enter and successfully complete the ISF program. When you're out, you will be on the mental health caseload so that you can get whatever help you need with medication, counseling, whatever it is. Once you get through that, you'll be on the high medium caseload, which also means you're just going to have to be you're going to go more often. Probation's going to have more things to help you. It's not meant to be mean or make you go more than other people, but with what you're showing so far, you need this extra help, okay? So if you do all of that, you're still on a deferred probation. You're still not a convicted felon. Today, just based on what I told you before about not getting in trouble, I could easily send you to prison for up to 20 years. Like that. And I understand that there's some behavioral issues going on, but I don't think any of those behavioral issues had anything to do with what you did to that correctional officer. Okay? Cutting up, maybe they're not being quiet, fighting, all that stuff, maybe there's some issues. But that was a conscious decision that didn't have anything to do with any other type of mental illness or help that you need to go and show her that. It was just being stupid. Right? So if you make a choice, that's a choice. That's not something that we're going to blame on anything else. I understand some of the other write-ups. That one, I don't buy that has anything to do with that. Right? So if you do anything like that, again, and you get in trouble, now that everything's lined out and you haven't been getting in trouble, if you do, before you go to ISF, we will not be having this conversation again. Okay? Same rule applies. It is a condition now of your probation that you not receive an incident report. If you do, we're back in here, and I don't care what anybody says. You're going to end up in prison. You've got family. Nobody wants this to happen. But it's 100% up to you at this point. Okay? If you get to ISF and you don't follow the rules in ISF and get in trouble there, same thing. That's a condition of your probation, is that you act right in ISF as well. Okay? All right. So anything else? And you'll be on zero tolerance, which means really everybody should be on zero tolerance when they're on probation. But when you're actually on what we call zero tolerance, it means you cannot make any mistakes. You're being given a huge opportunity to change your life, make better decisions. It's just going to be up to you to do that. If you don't, it's not going to be, well, this is a one-time mess up, give me another opportunity. Zero tolerance means you don't get another opportunity. Okay?
The judge made the stakes clear. One more serious violation, and prison becomes mandatory. This wasn't leniency. It was a final warning.